Okay, a very good morning and welcome to the 8th meeting of the Criminal Justice Committee in 2026. We have no apologies this morning, and our first item of business is an oral evidence-taking session on an affirmative instrument, and that is the Hate, Crime and Public Order Scotland Act of 2021, Characteristic of Sex, Amendment and Transitional Provisions Regulations of 2026. So we're joined this morning by the Cabinet Secretary for Justice and Home Affairs, and I also welcome to the meeting Patrick Down, Criminal Law, Procedure and Sentencing Team, and Jasmine Hepburn, Legal Directorate at the Scottish Government. So welcome to you all. And I refer members to papers 1 and 2, and I thank everyone who's provided written submissions to us. So I intend to allow up to 60 minutes for these items. So can I first invite the Cabinet Secretary to make some opening remarks on the SSI? Cabinet Secretary.
Good morning, Convener, and good morning to committee. The Scottish Government is committed to strengthening Scotland's criminal law to protect women and girls from hate and prejudice. That is why on the 28th of January 26 we laid the Scottish statutory instrument before Parliament, setting out our proposal to add the Characteristic of Sex to the Hate Crime and Public Order Scotland Act 2021. This marks a milestone in our work to deliver stronger, clearer hate crime protections, particularly for women and girls, who we know experience disproportionately high levels of harassment, abuse and threatening behaviour motivated by prejudice based on their sex. The legislation we have laid builds on the evidence and ensures that our justice system can respond as it does already to hate crime concerning, for example, race, religion or sexual orientation. As required under the Hate Crime Act, a draft SSI was laid and drafted in Parliament last year, and a public consultation was undertaken to seek the views on the draft. We have published an analysis of the responses we received to this consultation, which found that while there was a range of views, there was support from a significant majority of those who responded for both the addition of the Characteristic of Sex to the Hate Crime Act and for the specific approach taken in the SSI. I would like to take this opportunity to thank the numerous organisations and individuals who took the time to share their views during this process. The measures set out in the SSI will make a specific criminal offence to stir up hatred against a group of persons because of their sex, and ensure that where any offence is motivated by or demonstrates malice and ill will towards someone because of their sex, it may be treated as an aggravated offence, which is rightly recognised as more serious within our justice system. Designating sex as a characteristic under the 2021 Act ensures women and girls will benefit from specific hate crime protections, equivalent to those already in place for age, disability, religion and other characteristics. While these provisions apply to men and boys too, the evidence is clear and consistent that women and girls face the greatest harms most frequently and most severely. That is why, as I indicated in my evidence to committee in September last year, that I was not prepared to allow this gap to continue and that women and girls deserve this protection. It strengthens the tools available to police, prosecutors and courts. It sends a clear message that abuse driven by misogyny and sex-based prejudice has no place in our communities, and ensures that women and girls receive the same level of legal protection as victims targeted because of other characteristics in hate crime law. Protecting women and girls from violence and hate is not simply a legislative priority, but a moral imperative. These regulations represent a necessary further step towards a justice system that recognises and responds effectively to the lived reality of women and girls across Scotland. And thank you, Convener, and as always, more than happy to take questions.
Okay, thank you very much, Cabinet Secretary. So I'll now invite questions from members, and I'll bring in Liam Kerr.
Yeah, very grateful, and good morning, Cabinet Secretary. The Cabinet Secretary acknowledges that this is about protecting women and girls in law, and the policy note for this proposal suggests that it will implement Baroness Kennedy's first two recommendations. But it doesn't, because Baroness Kennedy specifically recommended, for example, a new statutory misogyny aggravation which operates outside of the Hate Crime and Public Order Act of 2021. And the Cabinet Secretary referenced the consultation, and many respondents to the consultation, which interestingly resulted in no amendments to what's being proposed, said that this mechanism is ill-suited to deal with the sorts of misogyny-motivated crime that women and girls are facing. So does the Cabinet Secretary accept that this mechanism being proposed is a poor second to a full Misogyny Act that women were promised? And what else is being lost by using this mechanism instead of bringing in a full Misogyny Act?
Thank you, Convener, and thank you to Mr Kerr. I refute that this is a poor second for the reasons that I've outlined today and previously. It is important that sex is included in the hate crime legislation. I've said before that I don't want to have a gap in terms of women and girls. It is a proven model for providing legal protections. And the protections for women and girls are also provided via, the Hate Crime Act for other characteristics, age, religion, orientation, disability, etc. And it's imperative, in my view, that sex is included in that. Now, the advantage of the hate crime legislation is that it exists. It is a proven model for providing legal protections. Will this be the last endeavour or the last step legislatively or non-legislatively? Well, I expect not. That will be an issue for the next Parliament. Hate crime legislation is effective in responding to overt behaviours, behaviour that is evidently based on prejudice, and obviously there's a particular evidence required for that. Where I have considerable sympathy and support is around the comments and views, for example, on misogynistic harassment. And that there are many organisations, including the work done by Baroness Kennedy, which I'm of the view, won't be lost whatever steps the next Parliament decides to take. Is there an argument for further steps that tackle more nuanced behaviour? Well, I think there is. I have an open mind with regards to the future, but I strongly refute that this is a poor second best. It's a necessary step, but I think we all, need to have the humility when we look at the scale of misogynistic behaviour, harassment, violence against women and girls, sexual crime. I think we would be doing a disservice to women and girls if we ever pretended that one measure is the silver bullet, and I would never be prepared to do that.
Well, on that point then, the Cabinet Secretary says it's important that sex is included in this legislation and that this is a proven model. But that is not how the government felt in 2020. And the government persuaded Parliament that we needed a standalone Misogyny Act. And I can well recall joining with cross-party colleagues during the passage of the hate crime bill and representing that we didn't believe that the government would bring forward the promised Misogyny Act. And it seems that we were right. But given that Baroness Kennedy reported in 2022, the consultation was launched in 2023, For Women Scotland's decision was this time last year, what work has actually been done on a standalone bill by this government since that was promised to Parliament in 2021 and its abandonment in May 2025 that would mean a new government could actually pick up and get something in place very quickly. And on that, could the Cabinet Secretary reassure colleagues that this isn't the end of the process? What can she be doing to make sure a new government can pick up, get going and get something in place?
Well, I mean, firstly, I respect the views that have been articulated, that there were some people in Parliament, probably sitting around this table, that argued for both misogyny bill and for sex to be placed in the Hate Crime Act at the time. The government most certainly was pursuing a misogyny bill in line with the Baroness Kennedy recommendations. Indeed, there was a draft bill published, so significant work has been done with respect to a standalone misogyny bill. It is nonetheless a complex area of policy and law, and I don't imagine for a minute that anyone who's sat round this table for a considerable time would argue otherwise. We do know that any bill brought forward in relation to criminal law has to be clear and unambiguous. That has been a matter that I think members around this table have always pursued, and for good reasons. But there are, policy implications following the Supreme Court judgment, and further work needs to be done in this. And there was insufficient time to complete, if you like, the next stage of that work prior to the bill being introduced and going through 3 stages of a legislative process this side of Parliament. And I think I don't think it's credible to speak to a standalone misogyny bill as anything other than a complex policy area, and it would certainly take our criminal law into an area that it hasn't been before.
Thank you. I certainly recognise it is a complex area, but the Cabinet Secretary will also recognise, well, I argued that this is a government that prioritises what it chooses to prioritise and makes time for what it thinks it should do. But on that delay point then, this doesn't come in, this won't happen until, or events will not become aggravators until post 5th of April 2027, which is over a year away. And the Cabinet Secretary said to this committee on the 24th of September last year, I am not having a gap in the law for women. But it appears that a gap has been acknowledged, because that's why we're doing this today. We know that this is a different concept from what Baroness Kennedy envisaged, and the Cabinet Secretary acknowledged it doesn't go the whole way to what Baroness Kennedy was saying. So it won't fill the gap, and that is a gap that will now remain for over a year. Given the Hate Crime Act has now been in for several years, what on earth is delaying the protection of women and girls for another 14 months?
So, I understand the question Mr Kerr raises. I think it's a more than legitimate question. My previous commitment was to ensure that we don't have a gap in the law. And as, again, members around this table will well understand, that there is always, or more often than not, a commencement period to allow for the implementation and preparation for the law. I wanted to take opportunity to bring forward the SSI, which was a super affirmative process. It was not a simple, straightforward process. It's not not overly complex, but it does have particular requirements that requires more attention and time than an affirmative process, or indeed a negative process. So we will address the gap in the law, but the point about the commencement will be 5th of April next year. It is an area that I had, via officials, discussed with Police Scotland very closely. And the strong advice that they had given me is that they need adequate time to train their police officers in terms of identification and application of the law, given this change. I would point out that with the passage of the Hate Crime Act in 2021, it wasn't commenced till 2024. So it is an area that I have explored and tested with Police Scotland. And they have been clear in their assessment and view that an achievable timescale for them to train their police officers supports a commencement of 5th of April next year.
I'm grateful. Convener.
Before I bring in other members, I wonder if I can just pick up on the point that you've just been setting out there, Cabinet Secretary, with regard to the time that Police Scotland will require to presumably put training in place and develop guidance and policy. I know from experience responding to hate crime as an operational officer isn't necessarily straightforward. It can be quite difficult sometimes to distinguish between a hate crime, for example, and an ordinary sort of criminal act, if there is such a thing. And also investigations can be quite complex as well, and often perhaps merit a partnership response. So I just wondered if perhaps the Cabinet Secretary can maybe just set out a little bit more about plans for training, not just with police officers and staff, but also with individuals working in sort of wider sort of stakeholder space who potentially would have a role in that sort of whole system response, if you like, to a hate crime being perpetrated, particularly assuming the SSI is agreed today, but particularly where the characteristic of sex is appropriate.
So it's a very interesting point, Convener, that speaks to the comprehensive approach that is required to the implementation and preparation of the commencement of this legislation, if passed. It is important to point out that Police Scotland is a partner in the Hate Crime Strategic Partnership Group, so there is certainly an opportunity there to have appropriate engagement with other partners to explore the issues that you've identified, Convener.
Okay, thank you very much. And just, I'm interested in just the partnership group then. Tell us a little bit more about membership and the kind of aims and objectives of the group.
So the partnership group has been established for a considerable length of time. I can't recall the date of its establishment. I suspect it predates my time as Cabinet Secretary for Justice. It involves a range of stakeholders that the Minister for Victims and Community Safety regularly engages with. And it was the group who helped to drive forward the hate crime delivery plan, which of course is broader, but it is nonetheless an important underpinning to our legislative approach. If it's not going to be too late for committee, we'd be happy to supply more information, unless, Patrick, you can recall off the top of your head the membership.
I'm sorry, I wasn't actually a member of the group myself and wouldn't like to give a definitive list of exactly who is involved, but it does include, for example, prosecutors, Police Scotland, various groups who support victims of hate crime, but we could come back to the committee in writing on that if that would be helpful.
That might be helpful. I'd certainly be interested in that, just to sort of understand a little bit about what their role might be, particularly in the context of what we're discussing today. So I appreciate that. Okay, thank you. I'll bring in Katie Clark, then Pauline McNeill.
Thank you very much. And Cabinet Secretary, if this instrument was to pass, it looks as if potentially we might have a situation where there's different definitions of sex in different parts of the bill, with both the use of the word sex and biological sex. Is that something that you would agree with?
No, I wouldn't. In terms of the definition of sex that's been used, this relates to Section 12 of the Act, which means that we're only enabled to give a definition of sex for the purpose of the characteristic of sex. So it's quite focused. And what is clear, I would certainly hope members would agree in terms of the documentation, is that sex is defined as biological sex, which is equivalent to sex at birth. And that is the definition for the purpose of the Hate Crime Act in terms of the characteristic of sex.
Mm-hmm. So when you gave evidence last year, you were quite clear that you were relatively restricted in terms of the framing of any delegated legislation that you brought forward because of the crafting of the original legislation. So did you look at whether it might be possible to have use of the same terminology in relation to sex throughout the bill, perhaps not using the Section 12 power, but in relation to other consequential powers within the bill? Is that something you explored? Because you will have seen the representations that are being made to the committee, but I'm sure to the Scottish Government by a range of organisations on this issue. And there is this view that the use of different terminology in different parts of the Act may mean that there'll be different interpretations. Is that something you explored in terms of whether, either using Section 12 or indeed another part of the Act, it might be possible to get a consistent definition?
So, yeah, that was explored, but I think, so I'll ask Jasmine to start off with us. I may come back in so that you can go over the technicalities, because I think your question is touching upon the perhaps some of the more commentary around interpretive provisions.
Yes. So when we were considering what the power to use here in order to add sex as a characteristic, we looked first to Section 12. There is, as you say rightly, other provisions. There's Section 17, which is ancillary provision. We looked through both and came to the view that Section 12 was the appropriate power to use here. And as the Cabinet Secretary says, it is limited to only amend the characteristic of sex and the associated interpretative provision at Section 11. So we were confined to that for that particular characteristic only.
So does the Scottish Government have a view on how sex should be interpreted in relation to sexual orientation? And would the provision in the draft statutory instrument in relation to sex be interpreted as referring to biological sex, leave the interpretation of sex as used elsewhere in the Act as being uncertain? Or is the Scottish Government saying that sex, whether that's called biological sex or sex throughout the Act, is to be defined in accordance with the Supreme Court judgment as biological sex?
So, worth emphasising that this is our work stems from Section 12, and it's specific to the to the characteristic of sex, the definition for the purposes of this. I think if I've understood you correctly, you are asking about the interpretive provision concerning sexual orientation and any interplay. It is the view of the government that this would not have a significant practical effect on the operation of the Act, and if someone is targeted for being gay, bisexual or heterosexual, the sexual orientation, aggravation or stirring up hatred offence will be available for that, regardless of whether they define their actual sexual preferences by reference to birth sex or lived-in gender. And if someone is targeted not because of their sexual orientation, but because they are, let's just say, in a relationship with a trans person, that could be covered by the transgender characteristic, as they would be targeted because of their association with a characteristic. Is there anything you want to add to that, Jasmine?
Only to say that the enabling power is very limited, and so adding the characteristic of sex is for that characteristic only. So it doesn't necessarily mean that it reads across that way, as Cabinet Secretary says. It is our sort of SSI here is to amend this particular characteristic, and that's as far as the power goes.
But you will have seen the representations being made, and you will be very aware of all of the arguments. So is the Scottish Government's view that sex in this Act will always be interpreted as biological sex in accordance with the Supreme Court judgment? Is that the view of the Scottish Government?
For the purposes of this Act, in terms of the in terms of hate crime, where it's targeted for people on the basis of their sex, yes.
Thank you.
Thank you. Pauline McNeill.
Good morning. It's quite complex, to be fair. But I think what you've said to Katie Clark is that in relation to the section of that the SSI refers to in relation to characteristics, that the government has decided to define sex by biological sex. But does that mean it's not defined elsewhere in the Act? So it's fair to say that it's defined for the purposes under section 12 for this section, but it is not defined elsewhere. It's just left without being defined. Is that right? It must be the case.
So could you repeat that? Repeat
Right.
your question.
So okay, I'm not saying that I understood it right, but I think you said to Katie Clark that you've used section 12 to contain within the section of characteristics only, as you want to add in the characteristic of sex. And for that section only, you're defining it as biological sex. Yes. But you're not defining it elsewhere in the bill. It's just left undefined. Is that fair?
That's correct.
Right. But we can't conclude anything from that as to what is meant by the rest of the Act. Only this bit, we know. Is that fair?
That's correct.
I think this is important because of the representations that we've had that Katie Clark referred to, both from For Women Scotland and the Trans Alliance, ITU. Yeah. Right, we've got concerns about it, but just on a technicality, the rest of the bill does not define sex.
So,
I think Jasmine said, yes, you don't define it.
so before I come back
don't
to
define
Jasmine,
Don't confuse me.
let me try and explain this in my own layperson's terms. I think of the Hate Crime Act in chapters. It addresses all the characteristics, and we don't want sex to be the only characteristic that's not in the Hate Crime Act. That's my view. I think the only place where there was discussion of sex was around sexual orientation, but because Section 12 is very clear, quite limiting, that we can only define sex for the purpose of policing in the sex characteristic. And I think in terms of so we have received correspondence, and concerns have been raised directly with ministers and officials from the Equality Network and the Trans Alliance, and we have corresponded with them. I think it is fair to say that we have a respectful difference of opinion on various aspects. But in terms of, I suppose, if the fundamental question is what does the Scottish Government consider the meaning of sex to be in the interpretive provision concerning sexual orientation, as it stands, it is hard to envisage circumstances where this would actually make a practical difference as to whether an offence was so aggravated, or whether an offence of stirring up hatred on grounds of sexual orientation had been committed. I know that there was commentary around this at stage 2 when amendments were lodged, which had sought to amend the definition of sexual orientation, which explained that the reference to people of a different sex rather than the opposite sex is intended to ensure that the definition is more inclusive, particularly for non-binary persons, and as such the definition is intended to cover attraction based on either birth, sex, gender identity or both. But if I can put this in lay people's terms, and Jasmine or Patrick can correct me, the thing about Hate Crime Act, for want of a better word, I mean, it's quite siloed, into these what I think of as different chapters, different protections, different characteristics.
Just a simple question.
Sorry.
But thanks for explaining that. That for the purposes of the characteristics, you've defined it. For everything else, for the reasons you've outlined, you have not defined it. As far as the Act is concerned, that was all.
Yes,
you haven't defined it.
Yeah, so it's been defined for the characteristic of sex.
Thank you very much. Now, just to address the question that Liam Kerr was talking about, because as you said, that you weren't Cabinet Secretary at the time. I think, just for the record, I mean, those of us who supported the addition of sex, it was to fill the gap. It wasn't the primary argument at all. It would be the same argument as the government would put today, that there should be a standalone crime. I just wanted to understand, in answer to Liam Kerr, you said something about the Supreme Court judgment. Did you mean that it was the Supreme Court judgment that was holding up the work in creating the standalone offence? Is that no, it wasn't?
No,
okay.
No, because in terms of my time as Cabinet Secretary, work was commencing on the Misogyny Bill, and there's been considerable work done in it. There's been a consultation. There is a draft bill. I think the only point I was seeking to make was that in light of the Supreme Court judgment, further policy work would need to be done. And as we know, the standalone misogyny bill is a complex area. There was, in terms of the working group led by Baroness Kennedy, there were issues that group didn't address, and that was in relation to if and how misogyny applies to trans women and trans men. And that's not a criticism in any shape or form of the work that was done by Baroness Kennedy. I'm just simply making the point that further work post-Supreme Court would be required, and there was insufficient time to do that work and get the bill through Parliament.
So, given you've adopted biological sex for the purposes of that section within the Hate Crime Act, could you not just have adopted the same definition for the purposes of the misogyny standalone crime?
Well,
I mean, what's the thinking about it?
that requires it still requires significant work to be undertaken, and without rehearsing all the arguments that have played out in chamber, there is a number of policy areas where significant work has been undertaken. Some of that work has been concluded, and some of that work is ongoing. So I don't think it's as simple or straightforward. In fact, I'm convinced it's not as simple or straightforward as the member suggests.
It's really just a general point that what we're doing here is adding characteristic of sex, and there is already separate provision for characteristics of transgender identity or variations in sex characteristics. That wouldn't be the case with an entirely new misogyny offence, so there would be a policy decision to be made that was more consequential about how and when and whether it should apply where a victim is or is perceived by a perpetrator to be either a trans man or a trans woman or non-binary. Not to say that the biological sex definition from the Supreme Court couldn't be adopted, but that would be a more consequential decision than here where there is already separate protection.
Okay, I mean, just lastly, I mean, there's a great deal of disappointment, obviously, and in gender in particular did not miss the government, to be fair. I mean, the one I picked out in particular was that for reasons that the work that Helena Kennedy did was so important, is that fundamentally I think there's agreement across the board that you don't want a crime that's asymmetrical because of the whole nature of misogyny. So the standalone crime was really what most groups wanted, and they refer to the CEDAW Istanbul Conventions about asymmetry between men and women's experience of gender-based violence. Instead, they require approaches to reflect the deep inequality and structural injustice and power imbalances. So, I mean, it is disappointing that we're not going to see a standalone offence by the end of this Parliament. But they also point out that the government's consultation, that more than half of the consultees did not accept that the SSI that we're looking at today is in any way an answer to the... And I don't think... I agree with Liam Kerr here. I don't think the government should give the impression that somehow you've achieved like 25–30% of what Helena Kennedy had recommended. You filled the gap, and I will be supporting the government today in doing so. I would have done it in 2021. But I have to say it is really disappointing that the progress has not been made in the standalone crime, which everyone accepts is actually the right thing in nature to do, and not just as characteristic in the hate crime legislation.
So I very much understand and appreciate the disappointment that's been expressed by Engender and others. I can assure you it was certainly on my agenda to do a misogyny bill. Where I suppose where I disagree is I don't think the action we are taking today is contrary to Equally Safe or conflicts with CEDAW. It is entirely correct that policy should reflect the gendered nature of violence, and that we have to recognise that in terms of the aggravation that is specifically concerned with crimes where crimes can be proven that the accused was motivated by or demonstrated malice or ill will regarding the characteristic covered by the Act. I suppose, like domestic abuse and sexual offending, well, I don't suppose we all know and accept that that's mainly committed by men towards women. I've always defended that gendered lens, that gendered analysis. and that is, reflected in things like, allocation of resource to support victims, awareness raising work. But it's also, when we're considering the law, the criminal law, if I just give an example, the domestic abuse offence applies to males as well as females, although, perpetrators, are, vastly, the vast majority of perpetrators are men. And my final point is we can have more than one approach to this. So I deeply respect and understand the disappointment that we're not pursuing a misogyny bill. But we can have more than one approach, and I would never present. I think this action is crucially important that I hope committee will support today, but I would never present it as our final resting place.
Thank you very much.
Rhona Mackay, then Ginny Hepburn, and then we will have to move on.
Thank you, Convener. Good morning. Just to say, I fully support this instrument that we're discussing today. But I am concerned that the transgender community feel less protected by the definition of biological sex being in this. I wonder, just for the record, and I know we've discussed it for the past half hour, but just for the record, can you say to the community that they are still protected, there is still a clause within the Act that it's not been watered down, and also people with a gender recognition certificate and people without, is there a differentiation there?
So my responsibility as Justice Secretary is to uphold everybody's rights in accordance with all of our laws and legislations and expectations as a country. The Hate Crime Act has specific provision for variations of sex and transgender identity. So the Hate Crime Act, currently protects a whole range of people on, the basis of age, race, religion, disability, transgender identity, sexual orientation. And what we are doing today is proposing, in my view, to fill a gap that's in our hate crime framework.
And I completely understand that. It was just to clarify and to reassure the transgender community that their rights will be just as strong within this bill as they were before the biological definition was added.
It is strongly my view that I am not proposing any action today that reduces the rights of others.
Thank you. Thanks, Convener.
Thank you. And Jamie Hepburn.
Thank you, Convener. Just to get some clarification on the record, what my understanding is, being the case is, in fact, correct, and this maybe picks up on some of the concerns that have been expressed to us and that Rhona Mackay was striving at as well. I'm correct in understanding that the aggravator relates to the motivation rather than the victim's protected characteristics per se. Now, I recognise almost in every case they will probably correlate with one another. And I think you make this point actually in your communication with, I think you cite the example of someone who might be from the Sikh religion, but the crime was actually aggravated by Islamophobia. That's the case, isn't it? So it's actually what has motivated the individual rather than the characteristic of the victim per se. I know that they will almost always be the same, but not necessarily. It's
the perpetrator's perception. And if a perpetrator commits an offence against an individual on the basis that they perceive them to be of the Muslim faith but actually the victim isn't. That's irrelevant. It's the perception of belief that the offender has.
Yeah.
And it's also, you know, important to stress the point that in terms of clarity of the law around hate crime is that in our framing of this, we have tried to ensure or limit overlap, again, because you need clarity in the law. But it's a debate that was, I think, well aired during the Hate Crime Act and its passage, and particularly in terms of when the Hate Crime Act was implemented in April 2004, that we had to make particular efforts to make that point, that it's the perception of the offender.
And also, just in a related point, a crime, there could be more than one aggravating factor across a range of protected characteristics, I presume.
Yes.
Okay, that's helpful. Thank you.
Okay, okay, thank you very much. So, if we can now move on to our next item of business, which is to consider a motion to approve the affirmative SSI on which we have just taken oral evidence. And can I remind officials, not that I need to, that only MSPs may speak in a debate on a motion. So can I invite the Cabinet Secretary to move motion S6M number 20601 in her name and make any brief additional comments she wishes to make?
Moved, Convener.
Thank you very much. Do members have any other points that they would wish to make?
Yes.
William Kerr.
Please. So very briefly, I wondered, Cabinet Secretary, you mentioned in a response to Pauline McNeill that there was a bill in draft for a misogyny bill. I wonder if there's value in order that the next government can pick up and run if that were to be in some way published or released so that stakeholders could comment upon it. The only comment I have to make, Convener, since we're in the debate section, is extreme disappointment that that we're here years after women and girls were promised full protection. And I mean, I well recall the powerful and good work done by the likes of Jenny Mara, whom the Cabinet Secretary will remember, and Joanne Lamont in the previous session to try and get proper protection. But instead, what we've got here is reduced protection, and it is delayed. I am not happy that Baroness Kennedy's report was 2022, because I think it's clear that the government has failed to do the work required in the interim to get us to a position where women and girls would have the full protection. Now, I appreciate that what's being proposed might go some of that way, and so for that reason I will be supporting this today. I think the Cabinet Secretary has an intervention.
Okay, thank you, Mr. Kerr. Just to put on the record that there has been substantial work undertaken on a substantial misogyny bill, and a draft bill was published and indeed consulted on, and all of that information is available. So substantial work has been done. It just remains the fact that further work is required.
Right. So I accept that, and I wonder if the further work since the consultation closed, that presumably has been ongoing for the last year or so, might be released because, and this is my final point, Convener, whilst what we have here today I think does go some of the way, and so I will be supporting it. I think what certainly I and perhaps my committee colleagues would be keen to see is the new government, however it is constituted, picking up and running with this issue. I make that point in the strongest possible terms on my own behalf. I don't speak for anyone else. Because I think this government has failed to protect women and girls, and I would hope, and I know the Cabinet Secretary will do all she can to protect women and girls, and I hope she will do whatever she can to help the next government take that forward. Thank you, Convener.
Thank you very much. And Pauline McNeill.
Very much. Yes, as I said in my questioning contribution, it will be supporting the government SSI today, because I've always believed that there's a gap that just should have been filled in 21. But I think I'm clear in my own mind that it was a standalone crime that really we would prefer to see, for reasons that are really eloquently set out by Engender about the nature of misogyny. I think, to be fair, I mean, the wonderful work that has been done has got to be recognised. I recognise a lot of work's been done on this, both by the government and by Helena Kennedy. If I'm being honest, I think perhaps the government should have been presented with the issue in the first place, which is that most women probably want to see a crime based on biological sex. And that isn't to say that there aren't other people with other characteristics that shouldn't have equal protection in the law, but the very nature of misogyny. And I'm sorry to say that that's probably what's held up the Misogyny Act, but however, it's for a future Parliament to decide. And I just wanted to recognise the work that had been done by everyone in this, and hope the next Parliament will take on. Thank you.
And Jamie Hepburn.
Yeah, it seems that everyone's supporting it, so I won't labour the point and take up too much time, but it strikes me that we shouldn't overcomplicate this process. This SSI looks to me to be an eminently sensible thing to do. The Act always left open that an SSI of this nature could be brought forward. I think we recognise the fact, maybe if we could go back, we would have done it differently and included it in primary legislation at the time, but we didn't as a Parliament. I think we should now make sure that we fill that gap. I am satisfied that in adding it, it doesn't restrict or impede the taking forward of charging an individual or ultimately prosecuting an individual. It doesn't disadvantage any other group specified so far. And I hear what colleagues say in terms of disappointment around the misogyny bill not having been brought forward, and perfectly entitled to be disappointed about that, and understand why there is disappointment. That doesn't strike me as an argument against taking forward this SSI per se. So I think we should agree it and pass it today.
Okay, thank you very much. I wonder if I can maybe just make a comment as well. I would share members' disappointment that the misogyny bill is not being taken forward at the moment, given the extent to which the work of Baroness Helena Kennedy and the working group was applauded and supported. And I just note, if I may, a quote from the report, which is that the idea, and I quote, the idea of creating a standalone offence of misogyny was finding favour with many women in Scotland because hate crime legislation is principally designed to protect minorities, and women are not minorities. Now, the report does go on to acknowledge the extent of work that has already been done in Scotland, particularly around tackling crimes of rape, sexual offences and domestic abuse. However, many potentially protective laws are hidden away in a myriad pieces of legislation, and some behaviours are so normalised that current law as it stands can sometimes fail to act. So I'm, just for the record, very supportive of any work that can be done to ensure that the bill in its previous form, as it was drafted, it can be brought back next session. Okay, thank you very much. So, can I just find out where I am on my script? Yeah, so the Cabinet Secretary has already pressed her motion. So the question is that motion S6M 20601, that the Criminal Justice Committee recommends that the Hate Crime and Public Order Scotland Act of 2021, Characteristic of Sex, Amendment and Transitional Provisions, Regulations 2026 draft be approved. Are we all agreed?
Yes.
We are. Thank you very much. And are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? And this will be published shortly. Thank you very much. Okay, so we'll have a short suspension and comfort break before we move on to our next item of business. Thank you very much. Okay, thank you, members. So our next item of business today is an oral evidence taking session on a supplementary legislative consent memoranda number 57C for the UK Government's Crime and Policing Bill. So joining the Cabinet Secretary for Justice and Home Affairs, I welcome Yvonne Edmund, International Justice Cooperation Team, Christy Adams, Organised Crime Unit, Patrick Down, Criminal Law, Procedure and Sentencing Team, and Shan Moreland, Child Protection Unit at the Scottish Government. So warm welcome to you all. And I refer members to paper number 3. So I intend to allow up to 25 minutes for this item. And can I invite the Cabinet Secretary to make some opening remarks on the LCM?
Thank you, Convener. I very much welcome the opportunity to discuss the supplementary legislative consent memorandum lodged in December in relation to those additional proposals in the UK Government Crime and Policing Bill which require the consent of the Scottish Parliament. I appeared at committee in October 25 to give evidence on the LCMs lodged in May, June and August 2025. Following this, the Criminal Justice Committee recommended to Parliament that consent be given for the provisions covered by those LCMs. At committee, I set out that further LCMs were anticipated. Since then, we have lodged a third supplementary LCM on the 19th of December, covering offensive weapons, child criminal exploitation prevention orders, online child sexual abuse and pornographic images. A fourth supplementary LCM is anticipated, covering remote sale or letting of knives and to apply the definition of law enforcement employer. I have recently addressed the questions raised by the Delegated Powers and Law Reform Committee in relation to some of the clauses which confer powers on UK ministers and which may be exercised within devolved competence. We have taken a pragmatic approach to this wherever necessary and hope to see this reflected in the committee's report. Where there are benefits to Scotland, the Scottish Government is happy to recommend support for legislative consent to the relevant provisions within this bill. The bill covers a range of important topics and I would like to draw committee's attention to some of the provisions. For offensive weapons, changes extend to Scotland that are being made on a UK-wide basis. These relate to penalties available for certain offences. This includes increasing the maximum penalty on retailers who sell relevant items to people under the age of 18 or under the age of 16 if domestic knives are being sold. And again, I hope that committee will support this step. Ensuring a robust approach is available to take against retailers who flout the law is important in helping to keep our communities safe. There are also provisions that require remote sellers of knives to report bulk sales to the police. Again, this is for all nations within the UK and a sensible preventative measure to help keep communities safe. The bill provides a new UK-wide offence to disrupt adults who criminally exploit children, supporting a UK-wide approach to disrupting child criminal exploitation. The offence was included in the second supplementary LCM and there is an additional clause that provides further clarity around activity that needs to be proved to establish guilt for the offence. It was omitted from that LCM in error and that has been included in the third supplementary LCM to rectify the omission. As well as the new offence, the bill provides new child criminal exploitation prevention orders. These civil orders are intended to protect children from being criminally exploited by adult perpetrators and to prevent the adult from future offending. There are several measures in this bill designed to better protect children from the spread of child sexual abuse material online. First, the bill creates a new offence that criminalises the possession, adaptation and distribution of AI tools used to generate child sexual abuse material. Last month, the Internet Watch Foundation reported that last year was the worst on record for online child sexual abuse material. By extending this measure to Scotland, our priority is clear. We are committed to protecting children and preventing offenders from using AI to create this serious form of abuse. Second, the bill introduces an offence covering the possession of advice or guidance, so-called paedophile manuals, that teach people how to create child sexual abuse material. This has two key purposes. It mirrors the offence already in place in England and Wales, and it updates the law so these instructions also cover AI-generated material. This ensures our legal framework keeps pace as offenders change their methods. Finally, the bill introduces a technology testing defence for designated bodies such as AI developers and child safety charities. This allows them to safety test AI models to ensure they cannot be used to generate child sexual abuse material, extreme pornography or non-consensual intimate images. This approach helps ensure products are safer before they reach the public, addressing risks proactively. My last point on the online child sexual abuse and exploitation provisions is that stakeholders, including the National Strategic Group on Child Sexual Abuse and Exploitation, have shown strong interest in these measures, underlining the importance of extending these to Scotland. The National Strategic Group recognises the serious harm children face online and the complexity of preventing it. This is also recognised by the Scottish Government, and later today the Cabinet Secretary for Education and Skills will be making a statement on our progress in protecting children and young people, which will also reflect our work on online safety. These provisions represent, Convener, an important step in ensuring that our criminal law keeps pace with evolving online threats. I am aware also of concerns that have been expressed in this Parliament about non-fatal strangulation and the normalisation of strangulation in sexual behaviour. Last year, the UK Government's Porn Review, chaired by Baroness Burton, highlighted the role of pornography depicting strangulation, which is widely available on the internet, in driving the normalisation of this behaviour. And the bill seeks to address this by implementing the review's recommendation to criminalise the possession or publication of pornographic images featuring strangulation or suffocation. The offence will apply across the whole of the UK. So just to conclude, Convener, these measures align with Scotland's policy priorities, and the legislative consent of the Scottish Parliament is essential if these measures are to take effect in Scotland. And as I mentioned, we do anticipate a further supplementary LCM, and I hope, Convener, that this brief overview was helpful, and as always, happy to answer questions.
Okay, thank you very much, Cabinet Secretary. So I'm going to open up to members now for questions. I wonder if I can maybe just kick off with a practical question that relates to the provisions around the child criminal exploitation prevention orders. So they sound very appropriate and reasonable. I just wondered if there would potentially be situations where they may overlap with, for example, a child protection order that we're all familiar with and is used on a regular basis in Scotland. So I just wondered if there might be any sort of overlap, or is the proposal around the exploitation prevention order that sort of quite clearly defined as dealing with specific types of offending that wouldn't necessarily sit within a regular CPO, if that makes sense?
I'll start, Convener, and I may ask Christy to come in. The purpose, the raison d'etre of a UK-wide approach here is a recognition of the cross-border nature of some of the child criminal exploitation, and we are all familiar with how those who traffic people, how they operate also on a cross-border basis as well. So the orders are varied in what they can do. in that they can prohibit an adult from doing anything described in the order and will require the adult to follow restrictions that are imposed upon them. The order, can be for must be for a defined period of 2 years as a minimum, or until a further order is granted. The Chief Constable of Police Scotland will be able to apply for the child criminal exploitation prevention orders, and it's also worth noting that prosecutors can make an application for an order of an adult who has been convicted of any offence. It doesn't necessarily need to be a child criminal exploitation offence, or if they've been acquitted through a special defence, found unfit for trial, or successful appeals against their conviction. I think in terms of overlap, there is a potential for overlap, particularly around human trafficking, but I don't think that has been perceived as being, particularly problematic. This is another tool in the box, but I'll just check with Christy in case there's other nuance that's relevant.
I'm not aware of any overlap with the child protection orders. As the Cabinet Secretary has stated, there is potential for overlap with the human trafficking and exploitation prevention orders and the risk orders as well. But it's hoped that these orders, these child criminal exploitation orders, will be more specific to that criminal offending of the adult, and they are specific just to the adult. However, we can go away and look at that kind of overlap and provide more information to the committee if that's
that would be appreciated. I think that's been helpful actually, because I think what you've done is clarified that the proposed new order, the criminal exploitation prevention order, is imposed on the adult, which is slightly different from a sort of CPOs that we're familiar with already. So that's helpful. But yes, any further information would be appreciated. Thank you. Okay, I'm going to open it up to any other members who have any queries. Liam Kerr and Liam Kerr.
Thank you. Good morning again, Cabinet Secretary. This might be slightly tangential, but I think the Cabinet Secretary will understand. On this LCM, so the Cabinet Secretary is content to consent to a new clause after clause 84, which concerns new offences of possession and publication of pornographic images which depict acts of strangulation or suffocation. Now, I agree with that, perfectly comfortable. The Cabinet Secretary will also, of course, be very aware of Fiona Drue's petition on non-fatal strangulation and what Fiona and many others want to see happen in that regard. Now, that, of course, concerns an offence of non-fatal strangulation rather than simply the images, possession and publication of images of this. Can I ask the Cabinet Secretary, since I have this opportunity, what is her view on such a new offence, and were she to be back in government in session 7, whether she'd be keen to take that offence forward?
So, as Mr Kerr, I think, will recall, I think he participated, there was a members' debate recently where I spoke at length around this issue, to the extent that I was incurring the wrath of the Deputy Presiding Officer. And he will recall the legislative provision that exists in Scotland that I set out. I did, I hope, fairly acknowledge that there are arguments for a specifically named offence, particularly in terms of data and public messaging. And of course, there's a bit of a dearth of data. But what we wanted to do was to ensure there was no unintended consequences, and that was around the issue of consent, because you can't consent to this behaviour, and there were some differences in the law in England and in Wales. However, we are going to consult on this matter and and a range of other matters that could potentially enhance protections for women and girls. And again, if my memory serves me right, I think Mr Kerr has been asking questions about this consultation, and all I can see is it is imminent.
Very grateful.
He won't require to be patient for much longer, Convener.
Thank you very much. Any other members wish to come in? If not, do any members wish to give me an indication of their views on the LCM before I move to the question of consent and any recommendations? No? Okay, thank you very much. So, is the committee content to recommend to the Parliament that consent should be given for the relevant provisions covered by LCM S657C? Are we all agreed? Yeah, thank you very much. Are members content to delegate responsibility to myself and the clerks to approve a short factual report to Parliament on the LCM? Thank you very much. Okay, thank you. So we'll have a very brief suspension to allow a changeover of officials. Thank you. Okay, thank you very much, members. So our next item of business is an oral evidence-taking session on an affirmative instrument, and this is the early removal of prisoners from the United Kingdom, amendment of specified time periods, Scotland Order 2026 draft. So joining the Cabinet Secretary for Justice and Home Affairs, I welcome David Doris, Prison Policy Team, Hannah Hutchison, Legal Directorate at the Scottish Government. So welcome to you both, and I refer members to paper 4, and we'll allow around about 20 minutes for this item. So can I invite the Cabinet Secretary to make some opening remarks on the SSI?
Thank you, Convener. In November, I attended committee to speak to the Management of Offenders Scotland Act 2019 and the Prisoners Early Release Scotland Act 2025 Consequential Modifications Regulations 2026. That was the first of 2 instruments relating to early removal of foreign national offenders. That instrument, which was approved by Parliament on the 17th of December, brought the point in the sentence from which the early removal period is calculated back in line with the automatic early release point for short-term prisoners as amended by the Prisoners Early Release Scotland Act 2025. It also amended the existing order making power, enabling Scottish ministers by order to change the proportion of a sentence which must be served before a prisoner can be removed from prison for the purposes of removal from the United Kingdom. The purpose of this instrument you are considering today is to facilitate the early removal from prison of individuals who are liable to removal from the United Kingdom or have the settled intention of residing permanently outside the United Kingdom. The instrument, utilising the recently amended order-making power, aligns the provisions with recent changes approved by Parliament to home detention curfew. Specifically, it provides that the minimum sentence required to be served before removal as possible is 15% of sentence rather than 1/4. It also increases the number of days working backwards from point of automatic release, within which the individual can be removed from prison from 180 to 210 days. These changes will provide a longer and earlier time frame for removal from prison for the purpose of removal from the country. As the committee will be aware, home detention curfew is not available to prisoners liable to removal from the United Kingdom. I hope committee is content to approve this instrument, which helps provide greater consistency in regard to the management of short-term custodial sentences and may help, albeit in a limited way, to mitigate the high prison population. Thank you.
Okay, thank you very much, Cabinet Secretary. So I'll open up for members' questions and I'll bring in Liam Kerr.
Thank you, Convener. Thank you, Cabinet Secretary. I have 2 questions, please. One is more process-driven, which I'll ask first. So can you just help the committee understand, please, what happens when this foreign criminal is released? i.e., are they sent somewhere where they're held and then they will be taken from the UK to wherever they're going, or are they released on a good bond that they will immediately remove themselves and take steps to do it? And then, of course, on a practical level, whether they do or not is perhaps open to question.
The crux of the question, is, Mr Kerr, is about immigration and enforcement. And it is the UK that have the responsibility for the removal and deportation of foreign national prisoners. What we are discussing or debating today for our purposes is the point at which the prison service can facilitate that, the point in someone's sentence. My understanding is that immigration enforcement, take people to, well, actually, I'm going to, do you?
Yeah, sure.
I just want to make sure I'm on the right piece
I can
here.
confirm that individuals are not just released into the community in Scotland. It is an agreed process between SPS and the Home Office, so that individuals would have an agreed point of departure, and the flights would be arranged, etc. So that's all part of the process when it is implemented.
But how does this work on a practical level? Because people will be watching this and saying, hang on, they're going to open the gates to let someone come out and say, look, there's your ticket, now off you go, head back to your home country. You will do that, won't you? I think people would be keen for more reassurance that there is an actual managed process from the gate being opened to the person landing in their home jurisdiction.
I can give assurances on that process that the Scottish Prison Service work very closely with immigration enforcement in terms of exchange of information or a handover. I just have some reticence about speaking about UK immigration enforcement when it's not within our devolved responsibility. Although I think I understand the motivation for asking the question. Also, by way of context, committee may recall that the numbers of foreign nationals that are currently returned are very small. And this is part of the motivation for this instrument, is to increase that number. I think in the past, I think the most recent figures show that in the last year, that the data was recorded, it's 17 individuals, and that we are quite beholden on support from the UK government in this area. And I've spoke before, I think, in reply to a question from Mr Hepburn around that there are only 4 immigration officers that are deployed to work with the Scottish Prison Service and Northern Ireland, and they're not currently connected in with Grampian or Inverness. So there are gaps, out of the 77 immigration officers that the UK government have to work with prisons. There is only 4 that have been allocated to work with Scotland and Northern Ireland. What I should say is that there is authority that rests with the Governor in terms of someone's release, so the Governor has to be satisfied that appropriate arrangements have been made for the departure of the individual.
Thank you. The second question I'd like to put, I get why this is being proposed. I think just listening to you, Cabinet Secretary, what I heard was that potentially a foreign criminal serves 15% of their sentence and then says, look, I'm going to reside permanently, I promise, in my home jurisdiction, and then they become eligible, they start going through this process. Isn't there a risk then that effectively saying, look, come to Scotland, commit a crime, you'll serve 15% of your sentence, and then you go home? Does that not end up looking like rather soft-touch justice that makes Scotland an attractive place to come to commit your crime?
So, well, I think the converse of that is true when you look at the low numbers of return. There is currently the UK sentencing bill, can't quite recall at what stage. It's completed. Is now an act? It's now an act. Where the UK government have the power to release foreign nationals, including long-term prisoners, at the very start of their sentence. So if people were motivated in the way that Mr Kerr has suggested, I would suggest that our nearest neighbour, much larger jurisdiction, would be a more attractive proposition in that regard. I'm not actually convinced that that is a motivation in Scotland currently. I mean, the numbers are small that are being returned, and it's in part because in terms of our release scheme as it stands, and it could only be, as parts of it could only be changed by primary legislation. It only applies to short-term prisoners, so those serving, 3 months or more, but less than 4 years.
Thank you, Convener.
Thank you. Can I just confirm then? I think what you said, Cabinet Secretary, was it would be for the Scottish Prison Service to sort of consider sort of suitability or eligibility, if you like, for removal under the early removal scheme, and then that is then referred on to the Home Office for consideration. But should a governor feel that early removal is not appropriate, then they could effectively veto that. Am I right in thinking that?
I don't know if I would describe it as a veto. I do have something here that I read about governors' responsibilities in this. You can just bear with me, Convener. Where is it? Yeah. So the prison governors in Scotland have the final say on whether a foreign national offender will be removed during their early removal window and must authorise all removals under the scheme. So actually, I think that's crystal clear.
Thank you very much. Does any other member have any questions? If not, we will move on. Okay, thank you, Cabinet Secretary. So our next item of business is to consider a motion to approve the affirmative SSI on which we've just taken oral evidence. And can I remind officials, note that you need reminding, that only MSPs may speak in a debate on a motion. So can I invite the Cabinet Secretary to move motion S6M number 20532 in her name and make any brief additional comments she wishes to make.
Thank you very much, Convener, and I would, of course, be delighted to move in my name. I just want to flag to committee in terms of my final remarks that there are exclusions for the early removal scheme that may be of interest and, I would contend, importance. For example, prisoners who are subject to notification requirements under Part 2 of the Sexual Offences Act 2003, prisoners who are subject to an extended sentence under the Criminal Procedure 1995 Act, those subject to a release order, and if the prisoner is subject to hospital direction under the 2003 Mental Health Act. And if the prisoner is subject to a confiscation order being made under the Proceeds of Crime Act.
Thank you very much. And can you just remind me if you moved the motion?
Yes. I'll move it again, just for assurance.
Thank you, Cabinet Secretary. Does any member wish to make any final points? Okay, so can I invite the Cabinet Secretary to wind up and press or withdraw the motion?
Press.
Thank you very much. So the question is that motion S6M number 20532 that the Criminal Justice Committee recommends that the early removal of prisoners from the United Kingdom, amendment of specified time periods, Scotland Order 2026 draft be approved. Are we all agreed? Thank you. So are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? Okay, thank you. So thank you. This will be published shortly, and we'll have another very brief suspension before we move on to our next item of business. Thank you. Okay, thank you, members. So our final item of business today, it's an oral evidence taking session on an affirmative instrument, and this is the Rehabilitation of Offenders Act of 1974, Exclusions and Exceptions, Domestic Homicide and Suicide Reviews, Scotland Amendment Order of 2026 draft. So in addition to the Cabinet Secretary for Justice and Home Affairs, I welcome Mary Hill, Criminal Justice Reform Unit, and Louise Miller, Solicitor, Legal Directorate at the Scottish Government. So welcome to you both. And I refer members to paper 5 and tend to allow up to 20 minutes for this item. So invite the Cabinet Secretary to make some opening remarks on the SSI.
Thank you, Convener. I would now like to discuss the affirmative SSI, which makes the necessary changes to secondary legislation made under the Rehabilitation of Offenders Act 1974 to allow information about spent convictions and alternatives to prosecution to be shared with a domestic homicide and a suicide review in Scotland. The committee will be aware that the creation of a statutory footing for domestic homicide and suicide reviews was established through the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Act 2025. The 2025 Act gained royal assent last year, and the provisions to bring domestic homicide and suicide review into effect will commence in full on the 1st of April this year. These reviews are not designed to apportion blame, but to ensure that lessons can be learned following deaths where domestic abuse is known or suspected to have taken place, with the aim of better protecting victims in the future. Section 25 and 26 of the 2025 Act place a duty on designated core participants in a review to cooperate with and provide information to a domestic homicide and suicide review, and on others to provide information to a review in response to a notice requiring it. Section 25(3) and 26(2) of the 2025 Act, however, generally prevent a holder of information from being required to produce it to a review where it is not information they could be compelled to produce in Scottish court proceedings. Section 25(4) and 26(3) of the 2025 Act specifically disapply this restriction where the material is covered by an exemption under the Rehabilitation of Offenders Act 1974. This was done to ensure that information about spent convictions and alternatives to prosecution could be obtained by a review where needed. These are the exemptions which will now be created by this affirmative SSI. To fully understand the circumstances surrounding domestic abuse deaths, the review will need to be able to wholly understand a perpetrator's relevant history, including when a conviction has been spent or an alternative to prosecution was offered. The reason for this is clear. Having access to all the relevant information about the background to a death will ensure the review can provide meaningful and maximum learning and recommendations. Importantly, in cases where this information is sought, the review panels will not be making any determinations about a person's legal rights or liabilities. There will therefore be no direct impact on the person convicted should information on their spent convictions or alternatives to prosecution be disclosed to a review. If a case review report is published, Section 28(2) of the 2025 Act requires it to be anonymised first, including to prevent jigsaw identification. As a further stopgap, each report will go through a process of quality assurance. Police Scotland and the Crown Office and Procurator Fiscal Service will form part of this process. Furthermore, prior to publication of a review report, a risk assessment will be undertaken and Lord Advocate approval will be sought. Collectively, these measures not only help to protect those who have died, their families, but it also helps ensure those with previous convictions are not identified. This SSI will therefore ensure that domestic homicide and suicide reviews in Scotland will be able to have access to all the information they require in order to make effective recommendations and ultimately prevent future deaths from occurring. I commend this SSI to the committee and I move the motion in my name.
Okay, thank you very much, Cabinet Secretary. So I'll now open up to members if you have any questions. No questions? Okay, thank you very much. In that case then, our next item of business is to consider a motion to approve the affirmative SSI on which we have just taken oral evidence. And can I remind officials that only MSPs may speak in a debate on a motion. So can I invite the Cabinet Secretary to move motion S6M 20637 in her name and make any brief additional comments she wishes to make?
Moved, Convener.
Thank you. Do members have any points that they would like to raise? No? Okay. So can I invite the Cabinet Secretary to wind up and to press or withdraw the motion?
Press the motion.
Thank you very much. So the question is that motion S6M number 20637 that the Criminal Justice Committee recommends that the Rehabilitation of Offenders Act 1974 Exclusions and Exceptions Domestic Homicide and Suicide Reviews Scotland Amendment Order of 2026 draft be approved. Are we all agreed?
Agreed.
Thank you. So, are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? Thank you. And this will be published shortly. So that brings us to the end of today's meeting. Can I thank the Cabinet Secretary and all your officials for attending today? And I now close this meeting. Thank you.